So, over the past few lectures, we've kind of begun our deep dive into the specifics of the Bill of Rights, starting with the very complex and crucial First Amendment. So, today we're going to shift our focus to, another highly significant but definitely fiercely debated provision, and that is the Second Amendment. And the Second Amendment has undergone a very remarkable transformation in its judicial interpretation in recent decades, which has led to some profound implications for gun control laws across the country. So let's begin, as always, with the text of the amendment itself. A well regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So at first glance, this might seem straightforward, but as you will see, its interpretation really has been anything but. So constitutional scholars and lawyers have often divided the Second Amendment into two distinct but related parts, okay? And the first part is the prefatory clause, and it's sometimes called the militia clause. Now, a well-regulated militia being necessary to the security of a free state. This part sets out what appears to be a purpose or a rationale for the amendment. The second part is the operative clause, or the right to bear arms clause. And this part is the right of the people to keep and bear arms, and it shall not be infringed. So this states the right itself. Now, the central kind of interpretive debate surrounding the Second Amendment for really most of its history has revolved around the relationship between the two clauses. So does the prefatory clause limit the operative clause? Does it? I don't know. So in other words, is the right of the people to keep and bear arms solely for the purpose of militia service, or is it an individual right that is merely informed by the militia context? Okay, so we're going to look at some cases and see kind of how the Supreme Court has definitively answered that question in the 21st century. So to appreciate the modern interpretations, it helps to kind of, understand the historical context in which the Second Amendment was drafted and ratified. So you have the framers who have this deep distrust of standing armies. They are viewing them as potential instruments of tyranny. And they believe that a well-armed citizenry that's organized into citizen militias was essential to national defense. So, and let's add into for suppressing like insurrections, which would have been like slave revolts, which was a concern for southern states, and also for serving as a check against a potentially oppressive federal government. So many understood there to be an English common law tradition or right for individuals to have arms for self-defense, particularly against threats to their person or their property. So for much of American history, and definitely through the 20th century, there were two primary competing interpretations of the Second Amendment that shaped the legal and the political debate. So the first is the collective right view, and this interpretation argued that the Second Amendment primarily protects the right of states to maintain militias. So under this view, the right of the people to keep and bear arms was seen as being exclusively tied to military or militia service. It was not understood as an individual right to possess firearms for personal purposes like self-defense. So if the purpose was militia service, then the right would only apply when an individual was part of or called upon to serve in such a militia. So this view was often supported by a reading of the prefatory clause as strictly limiting the operative clause. So for decades, many federal courts, including the Supreme Court, which includes the case of United States versus Miller, which I'm not going to talk about that, but we'll talk about it kind of in a limited scope. But they interpreted the Second Amendment through this collective lens, concluding that it imposed few restrictions on state or federal gun control laws as long as they don't impede the militia effectiveness. So the individual right view is the other interpretation. And this argued that the Second Amendment protects an individual's rights to possess firearms independent of militia service, though the militia context might inform the importance of that right. So, under this view, self defense was seen as a central purpose of the right. Okay. And this perspective gained significant traction in the late 20th century, and it was pushed by scholarly arguments and advocacy groups. So, for most of American history, the Supreme Court had said very little definitively about the Second Amendment, leaving this interpretive debate really largely unsettled. But that changed dramatically in 2008, I think it was, with the District of Columbia versus Heller. So, the District of Columbia had one of the strictest gun control laws in the United States. Its 1976 law effectively banned handguns, making it illegal to carry an unregistered handgun and prohibiting the registration of handguns. It also required that lawfully owned rifles and shotguns be kept unloaded and disassembled or bound by a trigger lock unless they were being used for a lawful recreational purpose or at a licensed shooting range. So Dick Heller was a DC special police officer who carried a gun for work but was prohibited from keeping one loaded at home for self-defense. And he challenged those bans, arguing that it violated the Second Amendment right to possess a handgun for self-defense in his home. So the issue before the court was, did the District of Columbia's ban on handguns in the home and its requirement that lawfully owned firearms be kept unloaded and disassembled or bound by some sort of trigger lock violate the Second Amendment to the Constitution? And the Supreme Court, in a very narrow decision, that's a 5-4, it held that the DC handgun ban and its related storage requirements did in fact violate the Second Amendment, and they were therefore unconstitutional. So Justice Scalia, and this one always is one of my things to kind of harp on, because Justice Scalia has always been very conservative in his opinions, and he wrote for the majority on this. And he gave a very detailed textual and historical analysis of the Second Amendment. And we have like the individual right that's affirmed. So the court concluded that the Second Amendment protects an individual's right to possess the firearms. And that is not connected with service in the militia for traditionally lawful purposes, mostly the self-defense in the home, okay? So this was a very pivotal part of the decision because it rejected that long-held collective right view. All right. Now let's talk about the prefatory clause's role. In this case, the court interpreted the prefatory clause, meaning a well-regulated militia being necessary to the security of a free state, as announcing a purpose or justification for the right. But it doesn't limit the scope of the operative clause. So Justice Scalia explained that the right of the people in the operative clause means an individual right, similar to how the right of the people is used in the First and Fourth Amendments. So the court acknowledged the importance of the militia, but stated that the core right of an individual to bear arms for self-defense predates the Constitution itself. Now, the biggest thing here is that it's not an unlimited right. So the court explicitly stated that the Second Amendment right is not unlimited. So Justice Scalia emphasized that, like most of our rights, the Second Amendment right is not an unlimited right. So he provided a non-exhaustive list of presumptively lawful regulatory measures that would not be called into question by the decision, including things like prohibitions on the possession of firearms by felons and the mentally ill, or laws that forbid carrying firearms in sensitive places like schools and government buildings, laws imposing conditions and qualifications on the commercial sale of arms, even the prohibition of dangerous and unusual weapons like short-barreled shotguns, machine guns, things like that. Now you have the dissent. And you have 4 of them, because remember, it was a 5-4. And the opinion was led by John Paul Stevens. Justice Breyer also joined, and they argued that the majority had misinterpreted the Second Amendment. And they contended that the amendment's primary purpose was tied to the militia service, period, and that the right was protected, the right it protected was collective, or it was at least strictly limited to the militia context. So they also warned that the majority's decision would lead to a flood of litigation, challenging gun control laws that would undermine legislative efforts to enhance public safety. So the impact of Heller was massive. Okay. So for the first time, it established an individual right to bear arms under the Second Amendment at the federal level. And it overturned prior interpretations, and essentially it shaped the future of gun rights litigation. Now, while it only applied to federal laws like, or federal areas like DC, it its reasoning clearly signaled that similar state and local bans would likely face constitutional scrutiny. So it kind of ignited this debate about the implications for the existing and future gun control laws across the nation. So following Heller is where you have the case of McDonald versus the city of Chicago. And Chicago had a similar handgun ban. So Otis McDonald was a retired citizen who challenged Chicago's ban, arguing that the Second Amendment right that was affirmed in Heller should also apply to the states through the 14th Amendment. So the question before the court was, does the Second Amendment right to keep and bear arms for self-defense apply to the states through the 14th Amendment's due process clause? And the court said yes, that it absolutely does, and it struck down Chicago's handgun ban. Now, Justice Alito wrote for the majority and said that the Second Amendment is incorporated through the 14th Amendment's due process clause. And it found that the right to keep and bear arms for self-defense to be one that is fundamental to our scheme of ordered liberty. And it's deeply rooted in the nation's history and tradition. But it continues the Heller standard. It reaffirms that the individual right is not absolute. And again, it is subject to reasonable regulation. Okay. So the impact of McDonald was that it extended the individual right to bear arms to state and local governments. And again, it drastically altered the landscape of gun control litigation nationwide. And it made the Second Amendment a far more active area of constitutional litigation. So next we have New York State Rifle and Pistol Association versus Bruen. This is a more recent case. It was like 2022, I think. But New York had a proper cause requirement for obtaining a license to carry a concealed handgun in public. And applicants had to demonstrate a special need for self-defense beyond a general desire for protection in order to obtain that license. So you have two individuals that were denied licenses, and the New York State Rifle and Pistol Association challenged that law. So the question before the court, of course, was, does New York's law requiring the showing of a proper cause to obtain a concealed carry license violate the Second Amendment? And the court said, yes, it absolutely does. So Justice Thomas wrote for the majority, and it created a new standard of review, okay? So the court rejected the two-step framework where the courts first analyzed if a right was burdened and then applied a means in scrutiny like intermediate or strict scrutiny that was used by most lower courts post-Heller. Instead, we have the text, history, and tradition test, okay? And so this new standard requires that the government must justify a firearm regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. If a regulation is challenged, the government bears the burden of showing that the regulation is analogous to historical laws, meaning like if it regulates in a manner that is consistent with tradition of firearm regulation, okay? And then we have the right to carry in public. And the court affirmed the right to carry handguns for self-defense outside of the home, which found that New York's proper cause regime was too restrictive and it was inconsistent with historical practice. Now, again, let's talk about the impact because we have another significant shift in Second Amendment jurisprudence, and it made it harder for states to pass certain types of gun control laws by requiring extensive historical justification. So it raised questions about the constitutionality of a whole lot of existing gun regulations not directly tied to the historical past. Now, it is absolutely critical to understand that despite the expansive language that came from Heller and Bruen, that the Supreme Court has again consistently affirmed that the Second Amendment right to bear arms is not unlimited. Okay. So even in the majority opinions in Heller and Bruen, they acknowledged that a long tradition of firearm regulation exists and it is constitutionally permissible. Justice Scalia and Heller again provided this non-exhaustive list of what would be considered presumptively lawful regulatory measures that would not be called into question by the decision. And again, Justice Thomas and Bruen reiterated that nothing in our opinion should be taken to cast doubt on the constitutionality of the other longstanding prohibitions. So these examples of historically valid regulations include things like prohibitions on the possession of firearms by felons and mentally ill, which I gave you guys this list earlier, but I want to give you a little more detail. And this is a widely accepted category of regulation, and it's based on the idea that certain individuals are deemed too dangerous or too irresponsible to possess firearms. For example, you can have a state law that makes it a felony for any person who was previously convicted of a violent felony to own or possess a handgun or rifle. And a violent felony would be something like an aggravated assault or an armed robbery. You may also have a federal law that prohibits individuals who have been adjudicated as mentally defective or having been committed to a mental institution from being able to possess firearms. And that often requires a court order or some other formal legal finding that's related to mental health. Now, let's go back to the laws carrying firearms in sensitive places. Now, this includes areas like schools, government buildings, polling places, courthouses, all of those things. And those are places where the government has a compelling interest in public safety and order and where firearms presence could be considered particularly disruptive or dangerous. An example of this would be like a city ordinance that prohibits the carrying of firearms concealed or open within 1,000 feet of, say, any public or private elementary or secondary school. Another example would be federal laws that prohibit carrying a firearm in a federal courthouse or, say, into what would be considered the airport's sterile area, which means beyond the security checkpoints. Or, say, a state statute that makes it illegal to possess a firearm inside of a legislative building or a polling place during an election. Now, we also have laws imposing conditions on commercial sale of firearms. And that's going to include things like regulations like licensing requirements, for gun dealers, background checks for purchasers, and waiting periods. And these are seen as regulating the means of acquiring the firearms rather than banning their possession outright. For example, if you have a federal law that requires all licensed firearm dealers to conduct a background check on prospective purchasers before selling a firearm, that's going to be fine. Or a state law that requires, say, a 5-day waiting period between the purchase of a handgun and its actual receipt by the buyer. And I'll do one more, like a local ordinance that is going to mandate that all firearm dealers obtain, say, a special municipal license in addition to their federal and state licenses, plus adhere to, like, say, specific security requirements for their particular premises. Next, we have the prohibition on dangerous and unusual weapons. And this refers to weapons that are not typically possessed by law abiding citizens for lawful purposes. And that would be your machine guns, your short barreled shotguns, and potentially any kind of military grade weapons. For example, the National Firearms Act of 1934, which was a federal law, it imposed strict regulations, including registration, taxation, special licensing, all of those things on machine guns and short barreled rifles and short barreled shotguns and silencers, effectively prohibiting most civilian owners to have them without some very specific and difficult to obtain permits. Also, an example would be like a state law that bans, say, the sale and possession of certain types of assault weapons, which would be defined by specific features like a pistol grip or barrel shrouds or detachable magazines or high capacity magazines. And those would be the ones that are holding more than 10 rounds on the grounds that they are not typically used for lawful purposes like self-defense or hunting. However, the new text, history, and tradition test from Bruin, it presents significant challenges in applying these principles. So one challenge is determining what constitutes a relevant historical analog for modern weapons and regulations, okay? So the types of firearms and the nature of society were vastly different in the 18th century. Okay, so how do historical restrictions on, say, a blunderbuss or carrying swords openly translate to assault weapons, high capacity magazines, or even red flag laws? And by the way, just let me pause for a minute. So a blunderbuss is a type of muzzle loading firearm that's characterized by a short barrel with a flared trumpet like muzzle. You probably saw them in cartoons if you were as old as me. But it was designed to scatter like a large charge of shot at a short range, making it particularly effective in close quarters combat or against multiple targets. But they were primarily used in the 17th to the mid 19th centuries, and they are considered historical artifacts today, not modern like functional firearms for, common use. So the red flag laws also are extreme risk protection orders. And they are state laws that allow law enforcement and sometimes family members to petition the court to temporarily remove firearms from a person who is deemed to pose an immediate danger to themselves or others. And these laws typically involve a court hearing, usually an ex parte initially, but followed by a more comprehensive hearing where the evidence of the individual's dangerousness, like credible threats or self-harm statements or even like violent behavior, is presented. So if a judge finds that there is significant, or sufficient, we'll say sufficient evidence of risk, then an order is going to be issued, and it's going to require the temporary surrender of firearms for a set period, after which another hearing is going to determine if the order should be extended or should it be terminated. But the primary goal of the red flag laws is to prevent gun violence by intervening before a crisis escalates. And I've got a story about that from somebody who's local to my students and myself, that this is a whole different challenge. But going back to this, so another challenge in interpreting the historical practices from, centuries ago in a contemporary context is the intent behind the historical laws might be ambiguous, and applying them faithfully to a highly urbanized, technologically advanced society that's facing different forms of violence is a little more complex. So lower courts are always struggling with that extensive historical research to justify or strike down the modern gun laws, which is a new and difficult task for the judiciary. And that's pretty much it that I'm going to give you for this one. But again, we've seen how the Second Amendment's interpretation has undergone a huge evolution from a long history of debate about whether the prefatory clause limits the operative clause to a collective right. The Supreme Court definitively ruling in Heller that it protects an individual right, to possess the firearms in the home, particularly. And then you've got McDonald that 2 years later incorporated it into the states through the 14th Amendment. And again, fundamentally changed the landscape across the nation. And then you've got Bruin, which is very recent, and it reshaped the standard of review for these types of cases, abandoning that common judicial balancing test in favor of a very strict text, historical, and tradition test. And again, the new test requires the governments to justify modern firearm regulations by showing that they are consistent with the historical analogs, and it significantly raises the bar when it comes to gun control measures. But the Second Amendment still remains one of the most politically and legally contentious areas of constitutional law. And it sits at that intersection of fundamental individual rights, public safety concerns, and very deeply held cultural values. Okay. And so now, as the lower courts are struggling with the new and demanding Bruin standard, we are going to see continued litigation challenging a wide range of existing gun control measures, and the precise boundaries of the Second Amendment's right in various contexts, from the assault weapon bans to age restrictions, to magazine capacity limits. Those will continue to be fiercely debated and litigated for really years to come. And that's pretty much it. Let me know if you have any questions. Bye.